Have you been charged with terroristic threat charges? What can you do about it? Is there a way to win your case? Welcome to the Fulgham Law Firm. I'm Jeff Hampton with the Fulgham Law Firm. Welcome to our YouTube channel. Today we're going to talk about terroristic threat charges. What does that mean? What can you do about it? Maybe you've been wrongfully charged. You need a plan of action on how to attack your case. By the way, if you waited around till the end of this video, I will also provide you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, now, I don't know about you, but when you hear terroristic threat, I've talked to many clients who've been charged with this, and they said, man, that sounds terrible. It sounds like some act of terrorism or something. And in general, that's what people think of. Some type of terroristic threatening or threatening violence that's involved, and it sounds awful. But I think it's important that we understand what Texas law defines terroristic threat as being and what type of defenses are available to you if you're facing this type of charge. Now, under Texas law, any threat of violence to either person or property can be the basis of a terroristic threat charge. However, that threat of violence must be accompanied with criminal intent to either follow through with that threat or to terrify another person into believing that you would do so. Now, you hear that old expression, sticks and stones will break my bones, but words will never hurt me. Well, the problem is, actually, words can hurt you. So even if you say these things and no one is actually hurt, you can actually end up being charged with a very serious crime that could end up landing you in jail, okay? Now, there are 6 specific types of intent. Now, when you look at terroristic threat, the main analysis, the legal analysis that's involved is the intent. Was there the specific intent involved in order to prove the crime? There are 6 specific types of intent covered here. The prosecutor only needs to prove that you had one of them in order to obtain a conviction. So let's go through some of those. Number 1, the intent to cause a reaction of any type to a threat by an official or volunteer agency organized to deal with emergencies. Number 2, the intent to place any person in fear of imminent serious bodily injury. Number 3, the intent to prevent or interrupt the occupation or use of a building, room, place of assembly, place to which the public has access, place of employment or occupation, aircraft, automobile, or other forms of conveyance or other public places. Number 4, the intent to cause impairment or interruption of public communications, public transportation, public water, gas, or power supply, or other public services. Number 5, the intent to place the public or a substantial group of the public in fear of serious bodily injury. Or number 6, the intent to influence the conduct or activities of a branch or agency of the federal government, the state, or a political subdivision of the state. Essentially, what we're talking about here is a threat to one of these people with the specific intent to create this response, to alarm these people, okay? That's what we're looking at. And depending on where that intent is directed will determine the severity of the crime. Now, let's talk for a few moments. What is the difference between a terroristic threat and an assault by threat, right? Because Texas law does make the distinction here. Terroristic threat is similar to one of the elements of assault under Texas law. And here's the thing, it is possible to be convicted of assault. It's known as assault by threat in Texas for taking actions that places someone in fear of serious bodily injury or death if that person believes that the fear that they have is an imminent bodily harm, okay? So if you place someone in fear of imminent serious bodily injury or death, and it's reasonable to believe that, you can be charged with assault by threat. Now, a terroristic threat can involve the exact same threat as an assault case. The difference, though, here's the big difference. The difference is the intent of the person making the threat. A terroristic threat could arguably still be committed if you had the intent that we've described here, regardless of whether the alleged victim was actually in fear of imminent harm or not, okay? So the distinction is important because you could end up you're not sure which is which. If you have the alleged victim saying they're in fear of imminent serious bodily injury or death, you could be looking at an assault. If not, but the facts show that the person making the statement intended for them to, you could be looking at a terroristic threat, all right? Now, let's talk about the punishment range on this. Generally speaking, a terroristic threat is charged as a Class B misdemeanor in Texas. However, under certain factors, you can have an increase of the range of punishment up to a higher level, Class A misdemeanor, or even a felony level for a terroristic threat. In the most serious cases, you can, with ones where you're talking about bomb threats or calling in where it has the most widespread effect on the public, you could have it classified as a third-degree felony. Now, charges for terroristic threat, like I mentioned, generally speaking, are Class B misdemeanors. Under Texas law, a Class B misdemeanor is punishable by up to 6 months or 180 days in the county jail and up to a $2,000 fine. Now, here's what's important. Let's say the person that supposedly was made the threat to, let's say there's a family relationship. Now you're talking about a terroristic threat of a family member. That could elevate the crime up to a Class A misdemeanor, and you now could be talking about up to a year in county jail and up to a $4,000 fine. That's important because here's my point. If you say something and it's a family member that you make this threat to, you could end up, even if you were to receive some type of deferred adjudication probation, you could end up losing the opportunity to get that arrest off your record for the rest of your life. And you could end up losing some of your gun rights under the law because it's a domestic violence related offense. Okay, now let's talk about felony terroristic threat charges. A terroristic threat charge can be upgraded to a third-degree felony where the threat impacted the public at large. Specifically, a threat will be charged as a third-degree felony if the intent was to cause impairment or interruption of public communications, public transportation, public water, gas, or power supply, or other public services, which I covered earlier. Or here's the big catch-all. It places the public or a substantial group of the public in fear of serious bodily injury. In other words, you hear these dumb bomb threat things that go on. People that call in and make that sort of threat or claim that. It puts people in fear of serious bodily injury or death. Well, what if it didn't? But what if they weren't really afraid? But what if it's clear that was the intent of the person calling it in? You could be looking at a third-degree felony, okay? Now, a terroristic threat charge can also be classified as a state jail felony if a threat was coupled with the intent to prevent or interrupt the occupation of a building, room, aircraft, or other places of public assembly. So the prosecutor must show, and this is important, the prosecutor in that situation must show that the threat led to damages of at least $1,500 for the owner of the property that the threat was made against. Now, a state jail felony is punishable by a minimum of 180 days up to 2 years in a state jail facility and up to a $10,000 fine. Now, very quickly, what are the defenses to terroristic threat? These are a few, just very short common defenses we're going to cover for a moment. Remember, this is a case all about intent, right? So if it's all about specific intent, it's all showing what the intent was of what the statements were that were made. The first thing you want to look at is the absence of a threat. For there to be a terroristic threat charge, there must be a threat to begin with. Words can easily be taken out of context. What someone might hear someone else say, they may construe that and twist that into whatever they want it to be, but it doesn't mean that's objectively reasonable, okay? So if words are taken out of context or witnesses are found to stretch the truth a little bit about what was said, and maybe there was a misunderstanding that happened, who hasn't been misunderstood? If that sort of situation takes place, if there was never an actual threat made to begin with, your experienced criminal defense attorney can exploit that because the state of Texas will not be able to prove that charge beyond a reasonable doubt. Okay, defense number 2, absence of intent. Ultimately, the prosecutor is going to have to prove the intent element of this crime in order to obtain a conviction. That means that even if there was a threat that was made, it may not rise to the level of a terroristic threat if the state can't prove that you had the necessary intent to commit the crime to begin with. So it's important to note that that if the threat is made, it could be considered a separate crime like assault, even if you are ultimately innocent of making a terroristic threat. This happens a lot. You'll have police officers who are unsure, should we charge them a terroristic threat? Should we charge them with assault by threat? And they may be a little unsure on it. This is where it makes a big difference as to who you decide to work with and partner with as your criminal defense attorney. Because your attorney needs to really dig into the facts, take a look at that video, look at the statements that are made, see if each and every one of these elements of the crime of terroristic threat can be proven beyond a reasonable doubt. Now listen, maybe you or a loved one has been charged, or maybe you're facing the prospect of a case against you for terroristic threat. If you are in the North Texas area, don't hesitate to contact the Fulgham Law Firm at 817-877-3030. And we'd be happy to give you a free case analysis, sit down with you and go over your specific situation. And by the way, I promised you if you waited around to the end of this video, I'd give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Click the link below. I'll send you that information. I'll send you a free ebook for you to go through. And if you have any questions, give us a call. Thanks for joining us here today. If you liked what you heard, subscribe to our YouTube channel, like this video. We'll see you on our next video series.